I would like to welcome you to the Mastercraft Advanced Startup Bootcamp on avoiding personal liability. In our previous video, we provided important facts for entrepreneurs starting the process of launching a new business. In this video, we will provide more detailed information which covers the critical issues which are often overlooked. This is Charles Monster speaking. Our focus will be on protecting owners and management from personal liability. This production is brought to you by the Mastercraft Law Firm with over 8 offices to serve our clients in Texas. We are all about launching businesses and look forward to an opportunity to guide you on your entrepreneurial journey. As we do in these videos, we will start out with a simple triangle which sets forth the main issues to address when protecting owners and management from personal liability. The first point relates to protecting corporate formalities. The second deals with contracts to avoid, and our final angle of the triangle is avoiding employee liability. Let's start with corporate or LLC formalities. By this I mean making sure your LLC or corporation is properly set up or formed under Texas law. Many times in a rush to get a new venture up and running, the founders neglect to focus on the critical elements of properly forming the entities under state law. It is generally easy to register a new LLC on the Texas Secretary of State website, but the operative effect is forming a shell without anything of legal significance inside. Simple registration and payment of a fee does not provide the critical formation documents to insulate owners against personal liability. For example, Texas law requires that a proper agreement between the shareholders or members of the LLC be drafted and executed, which is known either as a shareholders agreement or a company agreement. Additionally, resolutions need to be prepared and approved at an organizational meeting to complete the formation under Texas law, in addition to the issuance of stock or membership certificates, depending on the entity. These critical requisites are often neglected in the rush to get started and can be fatal to the long-term survival of the business later on. In a typical situation, a third party filing a lawsuit against the corporation or LLC will subpoena or request the records of the formation documents. If these are not provided, particularly if they were never done, it will create grounds for potentially piercing the corporate or LLC veil and holding the owners or management personally liable, a horrible result. Such a situation would be devastating and can easily be avoided if proper steps are taken at the inception. Another simple trick of the trade is to minimize the paperwork altogether by setting up an LLC versus a corporation, as the latter entity requires more specific documentation, including annual corporate meetings, etc. Failure to comply with these details and others can open the founders to personal liability. Conversely, an LLC virtually runs on automatic once it's formed with very little to no paperwork required. Keep that in mind. The second point on our triangle relates to contracts to avoid personal liability. This is often overlooked and can create major problems for owners and management, even if all the corporate and LLC requisites are met, which I just outlined. Depending on how a business contract is drafted, it could unfortunately negate the shielding offered by the entity and result in personal liability. Happens a lot. Keep in mind that all contracts are specific to the undertaking and the terms. It is always a good idea to have an experienced business attorney look over the final product to make sure that it doesn't inadvertently subject the owners or management to personal liability. Critically, the language used in the agreement must designate the entity structure of the company and make no reference to the owners or management in any capacity. That would create a potential basis for independent liability. Moreover, specialized language should always be included to exclude any basis for a customer or a third party to sue based on fraud or misrepresentation, which allows for an action to be brought against the individuals under state law in Texas, notwithstanding the existence of the entity itself. Court decisions which have come down from the Texas Supreme Court allow for the use of waiver and release language, which prevents a third party from filing an action based on fraud or misrepresentation. However, the requirements are very specific, and clients should always consult with an experienced law firm to comply with Texas law or do it at their own risk. Another business law trick of the trade, which is simple but overlooked, is never sign any contract in a personal capacity. Always include your full name, title, title and the name of the entity. Keep in mind that it is the registered full name of the LLC or corporation on file with the Texas Secretary of State, which must be used verbatim. Never abbreviate or leave out any of the words used in the original filing, as an argument could be made that the entity will default to a sole proprietorship for failure to refer to its proper legal name. That would be a horrible result. The final point on our triangle is the avoidance of employee liability, and this is an area which is, again, often overlooked. The key preventative measure is to make sure that all employees enter into a proper contract with the entity, regardless of the scope of work. This particularly relates to independent contractors, which create a huge risk of personal liability. Never, N-E-V-E-R, never enter into an oral contract with an independent contractor, because that will likely result in a situation where they argue that the oral agreement was between them and you personally, not your entity. That happens all the time, or quite frequently, and results in the potential for personal liability. All of this can easily be avoided by having a simple contract prepared. Also be aware of the possibility that an employee can bind the company through a doctrine known as apparent authority, which means that a third party doing business with an employee believes that person is speaking on behalf of the owner or management or the company. This is a major problem for the company and can also result in personal liability. It can be averted through proper language in the agreement with third parties, which makes clear that employees cannot bind leadership. Keep that in mind. And these are the critical three angles on avoiding or minimizing the potential for personal liability. Keep our suggestions at the top of your startup to-do list to avoid serious problems down the road. This is Charles Monster speaking, and I thank you for your time and attention. Feel free to call us at the number below with any of your questions. The first consultation is always complimentary. I wish you prosperity, good health, and happiness in all of your endeavors. And again, thank you so much for your attention. Take care.